Hillbilly food porn. Hillbilly food porn. As he said, good evening and thanks for doing this. This hopeless live goes better than last. Yes, I hope it has. You guys can all give me a thumbs up there on the chat. Thank you very much. Hey guys, I really do want to first apologize for my technical malfunctions. My technical malfunctions 2 weeks ago. I literally was sitting here ready to go live, and then I did something with the settings and effed it all up and couldn't get back to you guys. We did kind of this slap dick sort of live chat that didn't really work too well, but thanks for bearing with us. I apologize for not being able to get back to you the following week. I got to take a quick little spring break with the family, went to Honolulu. Let me give you a piece of advice. If you guys ever have a chance to go to Honolulu to unwind, don't go. Unless you like sitting in lines everywhere for everything. I mean, the weather's nice, but you're still sitting in lines everywhere. So anyway, so what I want to do tonight as people begin to start filling in, we got almost 100 of you on board right now, so that's awesome. Is I want to talk about a few things. I got a few little comments here. I kind of want to walk through some stuff, some observations I've been making, some things I want to talk about. Then I'm going to start getting to all your chats and your questions tonight and all of that stuff. And we'll run for about an hour, maybe a little bit longer. And hopefully I don't bore you all to death and we have some fun doing this. So, yeah, Luke, yeah, the Big Island. I'm personally a Maui guy. I'm personally myself a Maui guy, but, everyone needs to experience. My kids and my wife hadn't been to Honolulu, so they now get to say they've done that. I don't know if they want to say they did it again, but hey, to each their own, right? There's obviously a lot of people who do think it's great because there was a shitload of people there. But yeah, I'm more of an outer island guy like yourself. Okay, so let's get rolling here with some of my kind of opening thoughts, some things I want to kind of talk to you about. First of all, New York Pistol and Rifle Association v. Bruin. For those of you who've been geeking out on the channel for a while or have been following this stuff, and we're not alone in talking about this. A lot of people out here in the YouTuberverse have been talking about this case. But the state of New York has this goofy rule, and they're not alone in this. There are other states. But in order to get a concealed carry license, you must actually not only pass all of the characteristics that you need of being proper age and not a felon, not a DV perpetrator, things like that, being of good moral character, whatever that means, especially when you're having the state of New York define that. But you also have to state that you have a very good reason. You have a legally valid reason for why you need a firearm. It would be almost like if you want to go get your voter registration card, that you had to, I don't know, just explain why it is that you think you need to vote. But I digress. So that was challenged by the New York Pistol and Rifle Association. There were two plaintiffs in that case, both of which had applied for concealed pistol licenses. I believe both inside New York City, were summarily denied, as everybody else is. And that has now finally made its way to the United States Supreme Court. Oral arguments has already happened. And we are actually awaiting a ruling at any moment. I mean, we could literally get a ruling this week, next week, certainly before the term is out, before the summer hits. So that's going to be a huge case. Now, if you live in New York, New Jersey, Massachusetts, Maryland, Hawaii, California, and I know there's a couple of other dirty little perpetrators out there that are these may issue states. I think Delaware is one of them also. This ruling has the effect to basically overturn your concealed carry laws just that fast. Okay. Literally the signing of a pen, those laws can be struck down as unconstitutional. So pay attention. Now, what effect does that have on us here in Washington? It doesn't have a lot of effect on us here in Washington because although I am critical about the state legislature frequently, and I'm critical about our gun laws, 941-070 still makes us a shall issue state. In fact, one of the few areas of the law that I think Washington state actually has a pretty good system in place as it relates to non-COVID timing on issuance of concealed pistol license, even for out-of-state residents. So, but the other thing I want you to watch about New York Pistol and Rifle Association v. Bruin is that the Supreme Court recognizes that there are several other cases that are being asked to be reviewed by this court. Now, for those of you who haven't geeked out enough to know how this works, the Supreme Court, the United States Supreme Court, as the same with the Washington State Supreme Court. They basically get to pick and choose which cases they're going to want to hear. And so candidly, probably 9 out of every 10 cases that asks for an opportunity to be heard by the United States Supreme Court will not be heard. It's what's called a certiorari. It's a petition for review. And if it's granted, the court will accept review and set oral arguments and briefing schedules and all that, and away you go. But more times than not, you're going to be denied and say no. And whatever lower ruling the lower appellate court had issued will be the law of the case as it relates to that particular issue. So not a lot of cases get to make it all the way up to the promised land. Now, with the Supreme Court recognizing that there's a lot of other things coming their way, clearly we know that we have a magazine ban that's being challenged in the case of what used to be called Duncan v. Becerra, now called Duncan v. Bonta, and we have videos on that down there. And I don't see how the Supreme Court's going to avoid that one. I really don't see how they're going to avoid that one. Do they want to avoid more issues? If they want to avoid more issues, what they need to do with New York Pistol and Rifle Association v. Bruin is they need to make some very clearly and well-defined statements about what our Second Amendment rights are, what truly are our Second Amendment rights. And they could, in dicta, kind of start telegraphing to many of these lower courts what exactly is going on. And if you guys really want to geek out, what they can do is, for appellate lawyers, we talk about either a strict scrutiny analysis or an intermediate scrutiny analysis. And without getting too deep into the legal geeky woods here, what it really means is, how strictly are we going to allow or interpret a statute when we're trying to figure out whether it's constitutional or not? Now, strict interpretation always favors the Second Amendment, okay? A strict interpretation, because shall not be infringed is pretty clear language. So a strict interpretation really favors those of us who support and believe in what's written in the Second Amendment. An intermediate interpretation allows the court to engage in this little balancing act, like, well, maybe the society as a whole benefits more than the limited intrusion upon the individual. And so that's how the Ninth Circuit routinely upholds every single gun restriction that California has ever come up with. The court in that case alone could just say, hey, listen, for once and for all, just so all of you can understand this, when we're talking about reviewing gun control legislation, we are always operating under a strict scrutiny analysis. And that would put a huge dent in many of these gun grabbing efforts. So item number one, I want you to be careful. I want you to watch New York Pistol and Rifle Association v. Bruin. I do believe we're going to get an opinion out pretty soon. Okay. Hillbilly food porn, best name of the night too. The Ninth Circus is the most overturned court in the land. Yes, they are. And actually, if you guys want to know the quick history behind the whole magazine ban, the case, which is now Duncan v. Bonta, was brought originally in San Diego District Court. There is a judge down there who apparently is a firm believer in the Second Amendment. And so he banned it down. He struck it down. What he essentially did is he issued an injunction, said, nope, this law is unconstitutional. Of course, the state of California shit themselves immediately. Javier Becerra, who was the attorney general at the time, took it to the Ninth Circuit, thinking, well, here we go. I mean, the Ninth Circuit, of course, they're going to uphold us because they always do. They were assigned to a 3-judge panel, and they still thought they were in the promised land. And the 3-judge panel also upheld the injunction. So now the plaintiffs in that case are 2 for 2. Okay. Of course, the state of California shit themselves again. And this time they petitioned for a full panel review, which is all 11 justices. They got 11 in the Ninth Circuit, only 9 on the United States Supreme Court, but 11 in the Ninth Circuit, go figure. And of course, once they got all 11 of those judges together, knowing the political leanings of all of them, the writing was on the wall. I mean, that you could read the tea leaves and know where the numbers were. And so, of course, it was the lower rulings were overturned, and the California magazine ban was upheld and is now back in place. Now, I meant for a little interesting Freedom Week over there. But as Luke Helper talks about Freedom Week. Yeah, exactly. All right. So second issue I want to talk to you guys about real quick. Some people have asked, and this is why the chat's going to be a little sloppy again tonight like it was the first time, is I can do this thing called Super Chat, I guess, where you guys can pay to get in here. But I went to go set it up actually before the April 4th thing, and lo and behold, you actually have to have a monetized YouTube channel. Now, what many of you may not have realized is that when you watch our videos, you never have to watch an ad to begin with. You never watch an ad in the middle or anything like that. And the reason is I have never monetized the Washington Gun Law channel. Now, you're eligible, just so you guys know, and some of you probably have your own channel, so you know this. All you need in order to apply for monetization is 1,000 subscribers and 4,000 hours of viewing hours. So it's a tiny little dent before you can do that. And Washington Gun Law long past that up. Okay. But what my personal beliefs is for those of you who may not know this, I actually have a Facebook page. And when I first set up my Facebook page years ago with Washington Gun Law, it was killing it. It was great. I could boost posts. I could do everything. I was really drawing a nice, big, long, huge online community like I want to do. And then, of course, the Facebook started getting wise to it. And, of course, even though I do not, as most of you know, my material from Washington Gun Law is more like, hey, let me educate you about the law is. And I don't get super political. And it's hard not to get a little political when we're talking about our constitutional rights and people who are trying to take them. But Facebook basically just squished the hell out of the Washington Gun Law page. And it's I don't even know really why I have it. If y'all want to like it, that's great. I'm doing some stuff over there, but again, I have no faith in social media platforms in general, and certainly Facebook. My concern is that if I monetize here with the good folks at Google, and again, even though I am a legal education channel, I'm not really out here beating any 2A drums. I'm not really beating gun control drums, that's for sure. I try to stay kind of apolitical here. I'm just worried that, that's how Google starts messing with you. So I've resisted the temptation to monetize this channel and have not yet done so. And I don't know if I will. My wife convinced me to start a Patreon account. I'm slowly setting that up. So I will have a Patreon account. You'll start seeing the links down below on videos and things like that. And I'm going to start putting some original material over there so that for those of you who want to subscribe on Patreon, you'll actually get something for that. And we'll probably also have some retail operations over there. So for those of you who want to loudly and proudly display that you're a lawful and responsible gun owner in Washington State or nationwide for that matter, I will have the ability to do so. Okay, so next thing I want to talk to you about, and then I'm going to start I got two other things I want to talk to you guys about. Listen, I know most of you out there are lawful and responsible gun owners. That's awesome. Some of you, not so much. But all of us have a friend who, the guy who got busted with, an 8-ball of blow 20 years ago, the guy who got the Resberg 15 years ago, the guy who got rung up on kind of a BS type DV thing 15 years ago. The buddy you got, everyone's got him. And they lost their right to possess a firearm. And, for years they were like, whatever, I don't hunt. I'm probably never going to need a gun. And for many years, that's exactly how they lived their lives. And that's fine. Then fast forward to 2020, the world starts coming unraveled at the seams. We have local governments who want to defund the police, while at the same time we have state governments that want to disarm the rest of us. So, everyone's kind of really freaking out and realizing, hey, I really can't rely on anyone else to protect myself and my family, and I probably need to get my rights restored. So if any of you out there have individuals that are finally ready, or you've been on their ass forever, you need to get your rights restored. You need to get your rights restored. It's your brother-in-law. You guys talk about going hunting, but the guy's got to get his rights restored. I just launched a new website this last week. It's a super easy domain to remember. I couldn't believe that this had never been purchased before. I'm not joking. This was never purchased before. Super easy to remember. It's getmyrightsback.com. Pretty easy to remember. So and I'll put it down here in the chat feature later on when I have a chance to get over to that. But if any of you know somebody here in Washington State, it's got to get their rights back. And the problem has to have been created here in Washington State. So if you got a brother-in-law here who lives here in Washington, but he got 2 felonies in Georgia 22 years ago, he can contact us. We're going to set him up with a Georgia lawyer and get him all taken care of down there, because you have to go back to the state that the problem started at before we can start fixing this problem. But if the problem is here in Washington State, getmyrightsback.com. And when they're there, they can fill out this quick little questionnaire. I'll tell them in a couple of minutes whether or not they're eligible to possess their rights, to restore their rights, I should say. If they're not eligible, but they will be at a later date, it oftentimes could calculate and tell them exactly when they're going to be eligible. And then for some folks, unfortunately, they're kind of gone to a point of no return where they will never come back from that. And we can often figure that out pretty quick and let them know, so that they're not spending the rest of their life talking to other lawyers who want to figure out whether or not they can perform what is otherwise an absolutely impossible task. So that is one of the things that we wanted to talk to you about. Okay, the last thing here is, as we all know, last week, I think it was on April 11th, 1 week ago today, the Department of Justice published their proposed rulemaking. Now, we knew this was coming. This should not be a shock to any of us. I did a bunch of videos on that. But they issued their proposed rulemaking, which would redefine frames and receivers, unfinished frames and receivers. And basically, it was this huge onslaught on the 80% lower industry, the Form 1 kits and all of that. Now, is all of that greatly exaggerated? No, it's not all greatly exaggerated. Is some of it exaggerated? Maybe to some degree. And so one of the things that we do at Washington Gun Law, in fact, about the only thing we do really when you think about it, is we take really long, terribly, horribly written pieces of legislation and try to break it down into small, digestible pieces that all of us English-speaking folks can understand what the hell does this mean. And so I wanted to share with you guys some little nuggets that I pulled out of the whole ATF. Now, I put where I got all of this. Again, the link to this document is at the top of the chat box. So again, you don't have to take my word for it. You can do the research yourself. There's 365 pages, and you are absolutely welcome to read all of them like I did, or you can hear what I have to say. Now, the first thing I want to talk about, I'm going to list a few nuggets, and I want you to kind of try to help digest this with me. All right. So the first thing is, I think that in many ways, the ATF is, whether they're doing this intentionally or they don't realize they're doing this, I think that they are actually making any type of an assault weapon ban. And again, I'm using the term assault rifle. I know that now that I'm going to look over the chat feature, everyone's going to start shitting themselves because I'm using the term assault rifle. I'm using the terms used in the legislation, but assault rifle bans, assault weapon bans. I think that the language that the ATF is using in their comment section repeatedly probably could be interpreted as though the ATF doesn't believe that an assault rifle ban is constitutionally permissible. Now, there are some states, California and Maryland, that come to mind right away, and I'm sure New York's on that list, but I'd have to verify that have already done this. And we know other states, like this one right here, that's kicked the idea around. I believe it was Senate Bill 5217 was the bill. Okay, now, the reason I say that is because when I take a look at the comment sections written right here by your Attorney General, Merrick Garland, he says in here, in the past few years, some courts have treated the regulatory definition of firearm frame or receiver as inflexible when applied to the lower portion of the AR-15 type rifle, one of the most popular firearms in the United States. Okay? So this is your Attorney General, our Attorney General, Merrick Garland, saying that the AR rifle is one of the most popular firearms in the United States. Okay, now we all say, well, no shit, we knew that, right? So, okay, Bill, what's the big deal about that? Well, the language of what does the Second Amendment really truly mean is open to debate because our United States Supreme Court has for many, many years chosen to not accept review on cases. And the last time they did it was 13 years ago in the case of DC v. Heller, which is why you hear all the gun control or the lawyer geeks like myself on YouTuberverse here, out here in the YouTuberverse, cite to the Heller decision all the time. Why? Because it's the last good piece of law we got out of the goddamn Supreme Court. That's why it gets cited to. Okay, now, Justice Scalia, God rest his soul, a fine justice and a strict interpretist when it came to these types of things, had on multiple occasions in the Heller opinion said alone that taken alone, we recognize that an important limitation on the right to keep and bear arms, as we have explained, is that we always protect the sorts of weapons that are commonly in use at that time. Okay, and and he was also cited to another case, the Miller case, in which he said that. So the majority opinion in DC v. Heller said that we The Second Amendment always, always, always will protect the types of weapons most commonly used at that time. And the Attorney General, the proponent of any type of federal AR ban, would himself then admit, and has, that the AR is in fact one of the most popular firearms in the United States. Not just one of the most popular rifles, one of the most popular firearms in the United States. And I would have to take a look at what the sales are depending on different platforms, but we know them to be immensely popular weapons. So that's a little nugget that I wanted to give you guys. Now, there's a couple other nuggets, and I'm going to get through this real quick so I can get to your questions. One of the things that I wanted to talk about is the grandfathering. Oh my God. What are we going to do with all of these untraceable firearms that we have? Do they all have to be serialized, right? Now, we know in Washington State under House Bill 1705, an untraceable firearm is any firearm that's not traceable with a serial number that was manufactured after July 1st, 2019. Okay. And how are they going to establish when and ever you manufactured it? Don't blow me up in the comment section on that, because we all know the answer is there is no goddamn way. Okay. So this is in the comment section, and this is in response. This is Merrick Garland's comments to you, the lawful and responsible gun owners' comments to the ATF about this proposed rulemaking. I should say their comments to the Department of Justice. Okay. So this was about, oh my God, now how many goddamn firearms do we have to go out and serialize to get in compliance with the law? ATF, however, reiterates that personally made firearms, and that's the term they're using here, PMFs, personally made firearms, which is better than ghost guns, okay? Way better than ghost guns. It's a much more euphemistic label. So when I say PMFs, I'm talking personally made firearms, or what we call homemade firearms, okay? ATF reiterates that PMFs for personal use are not required by the Gun Control Act or this rule to be serialized unless it's required by state or local law. Instead, serialization is required only for those that are taken into inventory, which, as the final rule clarifies, based on ATF's longstanding view, does not include same-day adjustment or repairs, okay? So, hypothetically, let's say you have 5 untraceable firearms at home, okay? And because of how Washington law works, let's say that each of those firearms, for the sake of this hypothetical, were manufactured before July 1st, 2019. So they're not untraceable under Washington law. They are untraceable under this federal regulation, but they are not required to be serialized unless they go into the possession of an FFL. Now you're like, but what about repairs? What if I have to take my gun into repair? Okay, so this is going to be interesting. If the firearm has to stay overnight, it's kind of like your pet in a way. If your firearm has to stay overnight, okay, it's going to be taken into inventory by the FFL at that point. And yeah, if it's unserialized, it ain't coming back to you unless it gets serialized. I mean, that's right here in the comment section, okay? But if it's a same day service, get it in, get it out in the same day, then no, they don't have to do anything with it. Now, any unserialized lowers, receivers, frames, or firearms that FFLs currently have in their possession right now, there's no grandfathering them in. They're in their possession. They're going to have to be serialized. If they can't be sold, period. Okay, so that's one of the nuggets I wanted to talk to you about. All right, next thing. Suppressors, or what we call silencers. On the federal side, they call it silencers. Here in Washington State, we call them suppressors. And we know there has been a big, huge shit show, pardon my language, with Form 1s, large part brought on by the good folks at Diversified Machine and their solvent traps. Okay, now, it says here that when it comes to frame or receiver muffler device, it looks like some of those videos are like, oh my God, they're going to start including every freaking component in this. Now, and then, again, this is what the ATF says today. So, I could be doing a video next week about how they were completely full of crap about all this. But when it comes to Form 1 suppressors, building our own suppressors, And again, there was all sorts of comments. So this is in response to the comments from the public. In both the proposed and final rule, ATF requires only that the frame or receiver of a firearm muffler or silencer device be marked. And the final rule makes clear which part of the firearm frame or receiver of a modular silencer. What is the frame or receiver of a modular silencer? Additionally, the final rule makes clear that the end cap of a silencer or a sound suppressor cannot be a frame or a receiver. So, any of you got nasty ATF letters for buying end caps? I don't know why. Based on the public comments received for silencers and mufflers, the final rule will not significantly change the way the industry currently marks silencers. In most cases, the frame or receiver would be the outer tube. Okay. For those of you who are geeking out on this, that's page 261. Okay. Form 1 kits. Okay. All right. When it comes to Form 1 kits, we got some things that you need to be aware of. Number one, to clarify existing firearm parts kits with partially completed frames or receivers and personally made firearms owned or serviced by FFLs that were determined not to be frames or receivers as defined prior to this rule will not be grandfathered in. So what it basically means is that all the Form 1 kits that are currently sitting at FFLs are all likely going to need to be serialized. Now, big question, and I'm going to not bore you with all the details and all the notes got here. I don't want to get too bogged down, but we've been talking about who the hell is going to serialize these things. And there was this whole thing like, oh, well, it only can be the type of FFL who can manufacture firearms, right? It can't just be any FFL. Well, no, as it turns out, really anyone who's in the business of gunsmithing, and gunsmithing has taken a much broader definition in this statute, and it allows an FFL to contract the engraving work to an outside engraver, and there's certain hoops that everyone needs to jump through. So the ability for people to engrave unserialized frames and receivers, the legal ability is going to be there, okay? Now, whether or not it is worth any of them to do this and assume any of the scrutiny and bring the ATF, the wrath of the ATF you can bring upon you just for serializing parts. I don't know if I were in that business if I'd want to deal with that crap. I really don't. But that's one of the things that I wanted you to be aware of. And so those were all of my opening comments. Let me take a drink of water because that was a lot. Sorry to bore you guys. But we do got 240 of you online right now, so thanks a million. And hey, in the next week, probably in the next couple of days, we're going to pass 33,000 subscribers on YouTube, which is totally awesome. And so I want to thank all you guys, all you lawful and responsible gun owners. So thanks for everything. All right, I'm going to just start up here and start taking a look at some questions that you got. And then we'll just start going. So if you guys got some questions, start firing away here in the chat box. And I appreciate all the comments. I hope you guys had a great Easter. I hope the Easter Bunny was good to all of you. Question, and you guys can respond on this. I did a video I did a video about the Firearms Policy Coalition because they said in their article that they were looking for plaintiffs all around the state. And I was like, well, geez, I can help you out. I know about 33,000 potential plaintiffs in the state of Washington. So I did a video, I think it was called how can you help the Firearms Policy Coalition overturn our magazine ban? And I heard from a lot of you that FPC was ghosting all of you guys, that you were contacting them and you weren't getting anywhere with any of them whatsoever. If that's the case, let me see some comments down in the comment box about that. If you've had some success getting a hold of FPC about potentially being a plaintiff, please put that down in the comment section so the rest of the chat section so the rest of us can see that. But we'll go from there. Damian Kuntz. What about a ballpark cost to restore your gun rights? That's a good question, Damian. I wish I could give you a better answer. Here's the reality of the situation. Every situation is unique. And when it comes to restoring gun rights, it's really going to count on a few things. How many different jurisdictions do we have to deal with? For example, We can have individuals who like, I got a felony 20 years ago and it's in Pierce County, it's in Spokane County, it's in a county. Okay, great. Guess what? We got one jurisdiction to deal with. Okay. Then occasionally I might have someone's like, well, I got one in Skagit, one in Snohomish, two in Whatcom, and another one in Island County. Okay. And that's just the way it works for some folks. Okay. Now I got 4 different jurisdictions that we're going to be dealing with, you see. And so that can complicate things a little bit. All right. And then of course, then there's the whole issue of, can you be even helped on the federal level? So one of the things that we, getting back to restoring your rights, one of the reasons we want people to fill out the questionnaire and do a quick pre-screening is that I so frequently talk to individuals that have hired a lawyer, paid some money to hire a lawyer to get their rights restored, and then the lawyer tells them after they pay the money, I don't know if I can help you. Well, so that's probably something that should be figured out now. And so what we want to do is we want to figure that out. Can we help you now? Great. If so, then we can sit down and figure out how complicated it is and how much is it going to cost you. If we can't help you now, but maybe we can help you in a year, we can tell you that, and then we can talk in a year. And if there's no helping you, then there's no helping you. So that's kind of, it's not the answer you wanted to get, but, and there's other people jumping in talking about the pen, and there you can see the about $3,000, and then the next person says 1,500, and it depends on the lawyer, and it depends on the work. And do remember this about lawyers, everyone. Okay, good lawyers are not cheap, and cheap lawyers are not good. Okay, and that's just a good little piece of advice to live by. One of the other things I wanted to talk to you guys about, and if you haven't watched this video yet, I want you to watch this video. And I think that the Firearms Policy Coalition, if any one of you is watching, I also want you to pay careful attention to that. If we're going to strike down Senate Bill 5078, which, yes, is called the High Capacity Magazine Ban, but for the sake of keeping all of you happy, we will call it the Standard Capacity Magazine Ban tonight. Okay? The Totalitarian Magazine Ban. I just recently did a video about how the language of the Second Amendment and the fact that our rights shall not be infringed is powerful language. But if you take a look at Article 1, Section 24 of the Washington State Constitution, our rights can't even be impaired in any way. Okay. And so I'm going to give you a quick 2-minute crash course on the difference between federal constitution and state constitution. If you're a lawyer and joining us, I'm sorry, this is going to probably bore you, but some of you may learn something here. Okay. So the United States Constitution, our Bill of Rights, that is a guaranteed, at a minimum, we as all citizens are guaranteed these rights. And what it really means is we are guaranteed that the government can't take these rights from us because they're actually given to us by our Creator, God Almighty. And so when we use that they're constitutionally guaranteed rights, what we're really saying is that we're guaranteeing that government can't take these rights from you, okay? Because they were already given to you when you were born. Okay, now, so at a minimum, every state constitution has to guarantee the same thing that the federal constitution does. So your right to speak freely, your right to practice religion, your right to be free from search and seizure, your right not to have to incriminate yourself, your right to be free from cruel and unusual punishment, and anything else contained in the Bill of Rights has to be guaranteed to you through the 14th Amendment and this goes all the way back to the 1860s and the abolishment of slavery and all that, but at a bare minimum. Now, states, if they want, can actually guarantee you more protections than the federal constitution. And in Washington State, we've already done that in another area, okay? The Fourth Amendment guarantees us to be free from unreasonable searches and seizures, which means that we cannot have our private affairs invaded by a government intrusion unless we either consent to it or there is probable cause supported by a warrant or an exception to the warrant requirement. Absent that, we have an unlawful search and or seizure. All evidence obtained therefrom is fruit of the poisonous tree and has to be suppressed. Okay, that's the rule there. But in Washington State, under Article 1, Section 7 of the Washington State Constitution, we actually have a heightened level of protection. There's only about 100, 150 published cases in Washington that all say, hey, Article 1, Section 7 guarantees more protection from government than even the Fourth Amendment. So for all the defense attorneys watching here, you guys know this, gals, too. You know this, that when we're doing search and seizure issues, when we're arguing the legality of search and seizure issues, we never cite to the Fourth Amendment. We always cite to Article 1, Section 7, because it's going to protect us more. Well, if Article 1, Section 7 provides more than the Fourth Amendment, why can't Article 1, Section 24 of the Washington State Constitution provide more protection than the Second Amendment? And when you take a look at the language used in the Second Amendment, because a well-regulated militia is necessary to the security of the free state, the right of the individual to keep and bear arms shall not be infringed, okay? And shall not be infringed. But in Washington State, Article 1, Section 24, it starts off with the right of the individual to keep and bear arms in defense of himself in the state shall not be impaired. Period. That's how it starts. The next part of it talks about how you can't have armed bodies of men, which I did a video on the historical perspective of that. We don't have to geek out on that now. So, anyways, take a look at Article 1, Section 24 of the Washington State Constitution. And for those of you, Firearms Policy Coalition, if you're listening, you can cite to the Second Amendment all you want, but I think the language is actually even better in the Washington State Constitution. So, John McElfresh, Washington State Constitution is already telling them to F off. Yes, that is true. It might be telling them to F off. Okay. So is the Declaration, life, liberty, and the pursuit of property. Okay, that's good. That's good. How many, by the way, have you guys, for those of you who really geek out on this channel here, there was a couple of questions here about the, and by the way, if you guys got questions, type Washington Gun Law into the question. It does pop up a little bit easier if you go at Washington Gun Law. It pops up a little bit easier, like Jeremy. Jeremy doesn't have a question, but this one pops up. Appreciate the content. Veteran that just moved from Oregon to Washington and wanted to be sharp on the laws and regs from a good source. Just subscribe today. And then this started. Hey, Jeremy, welcome aboard. Welcome to Washington Gun Law, the home of Washington's lawful and responsible gun owner. Thanks for being with us. Don't know if we're going to give you any more freedoms here than the state of Oregon did, but you know, maybe you can then transition to Idaho or Montana from there and actually live free like Americans used to be able to, the whole country. Luke Barons claims to have restated his firearm rights for around $600 by himself. Luke, I'm going to tell you something right now. What he's saying is actually true. Can you do it yourself? Yeah, you can. You can. He's not pulling your leg when he says that. Can it be done? Yes. Do you have to figure out the forms, the procedures, the mechanisms, and all of that stuff? Yeah, you do. Can it be done? Well, Luke's living proof. Luke, congratulations. I'm happy that you did it. I'm happy you did it the right way. I was happy you were able to do it for yourself, man. That's awesome. 68 go, Matt. If I get my 80% lowers serialized in Washington State, am I good to go? If I can, who will do this? I'm not sure. We won't be able to get them all finished by July 1st. Okay, now remember this. Remember this. Good. Several questions here. 68 go, Matt. So thanks for that. Let's break them down. If you got your 80% lower serialized in Washington State, are you good to go? Yes. Now, of course, if you have an unserialized firearm that was manufactured prior to July 1st, 2019, that's not even considered an untraceable firearm, so you really don't have to do anything with that. But I digress. If I can, who will do this? Okay, that's a question that, and maybe you're just getting to it a little late. There are going to be a lot more people that are going to be allowed to do engraving than just particular, very tightly controlled FFLs. Whether or not you're going to actually find individuals willing to do that, that remains to be seen. The FFLs are going to be allowed to contract out to third parties, so maybe you can find some type of other commercial engravers that are willing to do this. I don't know. But the date, and this is important, yes, the law goes into effect July 1st, But the engraving, if you had an untraceable firearm that fell into that actual tightly defined category of untraceable firearms, remember, it has to be engraved by March 10th, 2023, exactly 1 year from the date in which the law was passed. Okay, so that's when you have to do it. So you actually have some more time, and hopefully we'll be able to figure out what the hell is going on with that. All right. You guys have some nice, colorful comments about lawyers, and here we go. There we go. All right. Cruel Kilgore. Can an AR-15 pistol use a folding brace adapter? Well, it would. Listen, here's the thing you need to be aware of, okay, is that when the AR or the ATF's rules as it relates to AR pistols go into effect in Form 4999, which you can find online by typing in ATF Form 4999, anything that suggests the firearm is meant to be shouldered is going to get points. The closer you get to 4, the closer you're going from AR pistol to SBR. The folding brace, I don't think is going to matter as much as whether or not that brace, when extended, is meant to be shouldered, which it probably is. Now, if it's a folding arm brace, it's a little different than a folding stock, right? Okay. Jeremy, let's go. That's cool. All right. Sunshine. What is the minimum age for working in a gun store? Because we're talking about the possession at a gun store, because we're talking about possession of semi-automatic rifles and pistols, I would imagine that the age would be 21. It might be 18. I can't see how a gun store would probably have younger employees, unless, of course, it's the owner's kid, because the kid's been around guns his entire life and he's safer than all of us could put together. But it's a good question. I imagine you could certainly work there at 18, and at 21, there wouldn't be anything that you couldn't handle in the store whatsoever. So, all right. Hillbilly Food Porn, still with the best name tonight. If you don't sell your personally made firearms, you're good. Well, yeah, actually, as we know, it's going to be unlawful to possess an untraceable firearm. That is one that's manufactured after July 1st, 2019. Come July 1st, unless, of course, get serialized. Of course, most of you people all have untraceable firearms that were manufactured well before July 1st, 2019, based on all the comments I'm getting. And can you still manufacture a personally made firearm? Yeah, you can. But now take a look at 1705, because 1705 is going to restrict the manufacturing of personally made firearms, even without the intent to sell. Okay, effective March 10th, 2023. Okay, so got a tight little window to do that if that's something you want to do. All right. Michael Riley, 5078 affect shotguns that hold more than 10 rounds, but split them up into multiple tubes, like the Keltec KSG 14+1 split up. Yeah, I replied to this. I'm not as familiar with the shotgun platform as I should be. I do own 3 shotguns, 2 pump action, 1 semi-automatic. But as I'm reading, and I pasted it in the comment section earlier, and this question was from Michael Riley. So, Michael, thanks a million for the question. There is an exception for a tubular magazine, but it has to deal with a lever action rifle. And I didn't see any prohibitions against shotguns. This is probably one of the many things that we're going to have to try to get an Attorney General's advisory opinion on. Now, if anyone wants to help me get an AG advisory opinion, I will gladly take your help. And this is the problem. I, as a lawyer, a practicing lawyer, licensed member of the Bar Association now in this state for 25 years, I can't just ask the Attorney General for one. I actually have to have a House of Rep, a congressperson or state senator do it, some of which might not even be licensed to practice law. So I can't get any of them to reply back to me. I'm sure they don't like enjoying talking to Bob Ferguson, so that probably is one of the issues. Bill Watts, on behalf of Bacon Melter 8400, asked, when do you have to update a current CPL with the new Washington driver's license number? You don't. You just have to update. Good question. You just have to update it when you go in for your CPL renewal. Your CPL expires every 5 years. You are eligible to renew 90 days from the date of expiration. Mine was coming. I actually went in to Kirkland PD. Kudos to the folks at Kirkland Police Department. I had 89 days to go, so I got right there, and I had mine back in I think about 12 days. So Kirkland PD has been awesome all the time. So no, when you go back in to renew, you can do it then. Now, if you want to go in and say that you lost yours or you want to replace it, you can do that, but there's no legal requirement to do so. Okay, and for those of you who are not CPL holders, shame on you. If you were otherwise a lawful and responsible gun owner, go get a concealed pistol license. How do you do that? You go to your local law enforcement department inside the city you live. If you live in unincorporated county, you go to the county sheriff's, except everyone in Pierce County apparently goes to South Sound 911. So get it done. Do it. All right. Rick Harris. Hyperion Precision does an SBR and a suppressor engraving. Not sure if they will do serial numbers or not. I'll email them and ask. Rick Harris. Okay, listen, I'm going to do another video about this. I'm going to do some of my little nugget videos, and I want you to, first of all, thanks a million for your support of the channel. What I also want you to promise me you're going to do is drop a comment in the comment section on that video when you find out what's going on, because this is exactly why I'm trying to build this community, is for guys like you to go out and experiment and learn and then share your knowledge with us. That's awesome. Dylan O'Connor. What would a person have to do with an unserialized firearm manufactured after the 2019 date? Are there state regulations for that? Yeah, you'd have to get it serialized. You have to get it serialized. You have to get it serialized by March 10th, 2023. The other thing you could do, I talked to a few FFLs, is, let's say you bought an 80% lower, stripped down lower, 80%. You milled it out, you assembled it, and built your firearm off of that platform. You could actually just go buy a finished lower and swap the lower out altogether. Do it that way. But if you don't want to do it that way, have to be serialized by March 10th, 2023. Okay. Black Fox 1933. Will any of this untraceable firearms crap affect the ability to build an AR-15 from a strip lower, serializing upper parts and more paperwork? Okay. By the way, in all of this nugget section that I talked to you about, I do, and again, the link's at the very top of the chat box. Okay, guys, gals. I'm not certain that we have to be serializing every goddamn part like we were thinking there. The upper, the bolt carrier, all that stuff. I think the lower receiver. If we are building, getting back to Black Fox 1933, if you go buy a strip lower, but it's a serialized strip lower, absolutely nothing has changed about that. That it's going to be serialized. You're going to go through a background check. You're going to go fill out a 4473. You're going to do all that stuff. So that is not a problem. This legislation does not affect any of that. You can continue to do so. All right. All right. Young Ling, moving to Washington at the end of this year. Do I need to replace all my mags to 10 rounds? Oh, well, first of all, Young Ling, if you can avoid moving to Washington, you might want to think about that. Okay, I've lived here my whole life, and candidly, if I was not as tethered to this state because of my law practice, I probably would look for an escape hatch. But I'm stuck here for now, and at least I'm stuck here with all of you guys, and that's awesome. Okay, so interestingly enough, yeah, see, if you bring those magazines in. That's a good question now. Let's think about that for a second. You're actually in the act of importing the magazines at that point. You're actually in the act of importing the magazines. And I just did a video on that. And I wanted to think it through for myself. If you're coming in at the end of the year, it's after July 1st. After July 1st, that would be the act of importing. Now, if hypothetically you shipped all those magazines to Washington State right now because you have a person that can hang on to them, there's nothing. You are importing the magazines at that point, but at a time when it's not unlawful to do so. They sit here. You're still the owner of the magazines. Then you come here at the end of the year. Voila. I think that could be done if you want to play within the confines of the law. But yeah, come July 1st, you're an out-of-state resident. You move here in November, and you bring all your PMags with you. That's awesome, but you're in the act of importing because you're bringing them from outside the state into the state, and they're staying here. Now, if you were visiting, because the video we did, Can I cross state line, Washington state lines with high capacity magazines? If you were visiting and you were going to leave with them, that's fine. That's not importing. You transported, but you didn't import, right? It's the importing that's illegal. So that's a good question. You might want to think about moving to another state, actually. All right. See how are out-of-state CPL requests affected in constitutional carry states? Okay, most states that have gone to constitutional carry have not done away with their actual concealed carry license. They're just saying that you don't need it if you don't want it. Now, as we know, the state of Utah, which is really probably I think the closest state to us that we have CPL reciprocity with, the state of Utah, God bless them, went to constitutional carry. And so most new gun carriers in Utah probably are not getting licenses. They don't need to, okay? They don't have CPL reciprocity here in Washington state, though. They don't get to show up and say, well, I'm a Utah resident. I get to constitutionally carry there. So F you, Washington, I get to constitutionally carry here too. No, that's not how it works, okay? They would have to have a Utah concealed carry license to carry in Washington, even though they wouldn't need it to carry in Utah. They could also get an out-of-state permit. Remember, any of you who are out of state, any of you who are joining us from somewhere else in the country, first of all, thanks a million for joining us. And secondly, under 941-070, you can apply for a concealed pistol license if you're an out-of-state resident at any law enforcement agency in the state of Washington. They have up to 90 days to issue that to you. So see how that's the answer to your question. Mr. F, do military need a Washington CPL if we aren't official residents of Washington, i.e. home record is Nevada driver's license? Okay, the statute to look at, we can look it up right now, but I want to get to the next question. But the answer to your question, Mr. F, is going to be found in RCW 9.41.060. It has all of the exceptions. Active military, I'm 99.99% certain that it is included in that. Take a look. You may have some other questions. You can contact me outside the chat and we can talk about that. I'd love to talk to you. Welcome to Washington State. Thank you for your service to the country too. AC Express, to what extent would the Washington State Constitution protect an individual's rights to unimpaired self-protection? Would it trump gun-free zones and employment restrictions, etc.? AC Express, that's a good question. That's a well thought out question. Now you're making me think. See, I'm stalling right now to kind of think this thing through. I honestly don't believe that a constitutional challenge to a gun-free zone would survive even under an expanded Article 1, Section 24 analysis. I really do believe that there are some reasons that the government could sell the reason for a gun-free zone, and I don't believe that it would be an infringement. I know that's not the answer you want to hear, but certainly. Now, we can debate the wisdom of gun-free zones all day, all night, and why do they always get picked as shooting targets. But you do talk about that impairment of our right to protect ourselves. And unfortunately, and this is the point I was making about the freaking state of New York and how the blood is on their hands a little bit. In New York with this whole May issue, nobody on that subway car, remember that subway car is a northbound out of Brooklyn. So for those of you who've been to New York City, northbound out of Brooklyn means you're heading to Manhattan, okay, at 8:30 in the morning. Who are all these people? Well, they're just good, lawful, hardworking, tax-paying folks that are shagging their ass into Manhattan to go work for the day, okay? And they're all good, lawful, respectful individuals, which means they follow the law. And if they follow the law, then the state of New York says you're not good enough to have a gun. You're not important enough to have a gun. Your life doesn't matter enough for you to have a gun. And none of these people are armed. And when that maniac pulls those smoke grenades and starts shooting that car up, guess what? What are the three things we do in a shooting? Run, hide, or fight, right? In that order. If we can run, we run like hell. If we can't run, we can hide. If we can't do either, it's time to fight because all bets are off at that point, okay? But nobody on that car could fight. Why? Because the state of New York made it so that they couldn't fight, okay? And shockingly, and this is what the folks who are against gun control measures, those in the 2A community always say is, well, the criminals don't follow the gun laws. And the reason they say that is because they're right. It's a very truthful statement. Do we really think that this maniac in Brooklyn, he was granted a concealed carry license by the state of New York? He was from Ohio, went to Pennsylvania, rented like a U-Haul van, drove to New York, went down there and shot the place up. That was all done lawfully. Okay. Take a look at the huge shooting in Sacramento. Oh, it was all about the guns. It was all about the guns. Huge shooting until the next day it comes out and it's a bunch of gangbangers, none of which are possessing a firearm, just indiscriminately shooting all over the place, picking off innocent bystanders. That's what's going on. Okay. It's rarely do we see lawful or rarely do we see serious shooting incidents where the dude bought the gun at Cabela's an hour later. Brian Travis. Can we legally conceal carry a registered SBR in Washington? Okay. So when we say legally registered SBR, short-barreled rifle that is registered with the ATF, paid the tax stamp, they've given you the ATF blessings, congratulations. Can you carry it? Yes, you could. You could open carry a rifle. Open carry of rifle is allowed. Now, under RCW 9.41.270, we cannot carry a weapon or display a weapon in a manner that threatens or intimidates others. And yes, I recognize that many of you would go, well, the mere presence of a firearm is not threatening, and I agree with that. However, to many, a short-barreled rifle, especially in an AR-style platform, might freak a few people out. Can you carry it loaded in the automobile? No, you can't, because even though it's an SBR, it's still a rifle, and under RCW 77-15-420, we cannot have shotguns or rifles loaded in the car. So that should answer that question for you. Let's take a okay. Marco Pena. Could you please explain at what point an unarmed attacker becomes a deadly threat or presents an imminent threat of great bodily injury? Okay, Marco, can I give you bright line rules? Not necessarily, okay? But here's the thing. If an attacker comes towards you that's of equal size and it is relatively a fair fight, his initial movements upon you probably do not place you in imminent threat of death or serious bodily injury. They do, in fact, place you in imminent threat of some injury for sure, and therefore the use of some force would be absolutely permitted. Now, maybe the attacker turns out to be much more skilled at fighting, much stronger, or perhaps he just gets a disadvantage of somehow to you, and he goes from a potential beatdown to now I am in serious risk of really getting worked over, or worse yet. Okay, now the use of lethal force becomes more legally plausible at that. Now, take a look at the little 75-year-old lady who's about to be attacked by a 25-year-old dude who happens to be 6'4", 260, and built like a brick shithouse, okay? Does she face the likelihood of death or serious bodily injury more than if it's a 31-year-old guy who's 6 feet and $195? Okay, yeah. Both people are facing a potential beatdown if we're talking about just size and strength, and that's the only analysis that we're looking at. The little old lady obviously has a much heightened risk of running into serious bodily injury or death, and therefore she probably would be justified in using lethal force sooner than the other person. Hopefully that kind of answers that question for you. It's a good question, though. I like that. All right, hillbilly food porn. I live in Oregon, and I'm seeking out credentials to perform concealed carry classes. Listen, I put one way up at the top. Sean Curtin. Sean Curtin has done my got an Arizona concealed carry because Arizona's got really nice reciprocity all around the country. So Sean Curtin, but again, there's a lot of folks out there doing it. Do I endorse Sean? Yeah, I've done his classes. I like him. I know Sean personally. I think he's a great guy. I think he's a good instructor, and his classes work. So am I endorsing him? Yeah. Am I saying he's the only one out there doing it? No, there are others. I just don't have a relationship with any of them. Okay. Rodney Hobbs. Yeah. Okay. So Rodney Hobbs, you were talking about, can he leave him at a friend's house before the band begins? Yeah. I think he can ship him to the state ahead of time when we're talking about, I don't remember the gentleman's name, but he's coming to the state. So I appreciate it. Bill Watts, what do you got for us here as we get to our Nukem Dukem. Can you be our next governor? You know, I've had that question, and I've had the question about running for attorney general, both asked of me. And I am very flattered, and I will tell you that there's no way in hell that that's going to happen. I am not meant for government work. I did work as a King County prosecutor and a Spokane County prosecutor for a while, and I had killer bosses at both Jim Sweetser in Spokane and Norm Mailing, which is a great pleasure to work for Mr. Mailing in King County. So I had a good experience working for government. I did because of my mentors, but government work's just not for me. I like being out here with you folks. I really do. Dylan O'Connor, do I practice in Spokane? Washington gun law practices statewide. We are called Washington gun law for a reason. I have a couple of cases in Spokane right now. I look for excuses to get to Spokane all the time, especially when the weather starts getting better, because the golfing over there is insane. All right. Okay. AC Express. How practical would it be for an FFL to serialize 3D printed gun parts if they were manufacturing those parts themselves using a 3D printer? How practical would it be? I don't know. I think that's a question that's probably better for people who really understand 3D printing gun parts. That's not me. I barely understand 3D printing at all, let alone questions like that. Braulio Cuevas. Side question. I'm in the process of opening a gunsmith store front of Nassau County, New York, FFL application. Do you know an attorney in New York that I consult with? I might actually have a list right here. So I probably shouldn't be doing this on out there on the YouTuberverse, but I might do it anyways because we're running out of time anyways. I don't have one for you right now, but hey, call me at the office tomorrow and we can talk about that. I'll get you guys. Good luck with that. Good luck with that. I just did a video and I kind of beat up on your state, and I'm sorry about that. Graham, how far do ammo or loaded magazines need to be from a rifle and an automobile? Far enough away that the gun's not loaded. That's it. Just far enough away that they're not loaded. So you could have the ammo sitting right next to the rifle or the shotgun. It doesn't matter. Just as long as it is not loaded. There's a video on my YouTube channel that will talk about that. What is a loaded gun? Isa C, how would it pan out if my everyday carry, my P80 built before July 1st, 2019, and I used it to defend myself? It'd work out just fine if it fires, if it functions as you say. Well, it'll work out just fine if you put your shots on target, right? How will it work out legally for you? The bigger issue will not be the legality of the firearm. The bigger issue will be the legality of the trigger pull and whether or not you were lawfully allowed to do that. Would I personally carry an untraceable firearm? I personally would not. I have plenty of reasons. I'm not going to preach to people on here. That's not the purpose of Washington gun law. So that's my own 2 cents. You obviously get to do you, and that's important. Nunya Biz says you don't need to go through a class to get your CWP in Oregon. That's good to know. Joe Schmo. All my AR pistols were built prior to 2019. Of course they were. And congratulations. You were on the cutting edge of that stuff, Joe Schmo. You were doing it before it was even cool to do it. Do you have to serialize them under Washington law? No, you don't, because they don't classify as untraceable firearms, see, because they were built before 2019. Then you biz, I'm not going to go for Oregon governor. I'm not going to run for Oregon governor too, okay? Listen, hey, everyone, we have 284 of you online today, and that's pretty good for a dude who totally effed up 2 weeks ago and promised you guys a live session and then completely screwed the pooch. So thank you for coming back. Thank you for sticking with us. For those of you down at Tacoma, I want you to know that I'm going to be at the Tacoma Sportsman's Club on Thursday, May 5th, Cinco de Mayo at Tacoma Sportsman's Club. That's right behind the Amazon warehouse at 6 o'clock. Going to be talking to all of you about the new gun laws, how it affects you, and we'll also talk about some laws of self-defense. Listen, the other thing I wanted to pass on to you guys is if you have a group of individuals, I got the pleasure of going over to Spokane about a month and a half ago, a church security team, big, huge community church out there, New Life Community Church out in Spokane Valley. If any of you guys are watching, hi to you. Great facility out there. Amazing. anyways, they got a big security team out there. And I went out and did a presentation for all the guys working security. They had some really good dudes, a lot of former and current law enforcement. So they are well secure over there, by the way. So anyways, it was a great group. And we went over there and we put on a presentation, just taught them about the laws of self-defense and got their questions answered and all that. If you got a large group somewhere, whether it's church security, private security, like that, you just got a large organization, whether it's a gun club or anything like that, and you want to contact Washington Gun Law about coming out, talking to your folks, doing a presentation on just about anything, we love to do that. The entire purpose of Washington Gun Law is to educate all of you so we can all be the lawful and responsible gun owners. So always don't hesitate to contact us at WashingtonGunLaw.com. You can call us directly at 425-765-0487. But I want to thank all of you guys. Like I say, we're about to pass 33,000 subscribers. It would not be possible without all of you. So listen, I'm going to get rolling now. It's about 8:04. But listen, everyone, remember, you always got to know what the law is in every situation and how it applies to you in any instance that you may be. That's the only way that we can ensure that we're going to remain the lawful and responsible gun owner. Now, listen, we'll be back on Monday, May 2nd, 7 p.m. for another live chat. Thanks a million, everyone. In the meantime, all of you, stay safe. Take care.